From daily list, fixed case, item 1, SA 196 of 2020. Okay. First appeal 3 of 2023. Item 2.
Yes. My leadership, before starting the case, this is my very first time I'm arguing before a court. If there is any mistake, I beg your pardon, my leadership.
No, there will be no mistake. Read it.
My leadership, the appellant has came for the setting aside the judgment which was passed on 15/3/2021 by Civil Division towards Saraikela. The case of the plaintiff is that the plaintiff was initially appointed as a clerk in Bank of India. Then he was promoted in a officer rank. Then there was a purchase of a second-hand car by the appellant by taking a loan from the bank. Then in 31/3/1983, the appellant was served with charges for the tenure of 1973 to 1978, in which all the charges were there were some procedural irregularities of the appellants, except for Article 6, in which the charge was related to the purchase which the appellant has made. Then the inquiry was made and the penalty was awarded as reduction of the scale by the 7th stage. Then the appellant has went to appellate authority, in which the appellate authority has reduced the 7th stage to 5th stage. Then in this, there was a second notice served to the appellant in 1986 for the effect from 21 to 1981, in which a company was allowed overdrawn by the mistake of the bank, in which the bank has said it was the fault of the appellant. In this also, the appellant was charged for reduction of the scale by 5 stages. Then the appellant has went to appellate authority, and it was then reduced by 2 stages. Earlier it was 5 stages, then it was reduced to 2 stages. Then the appellant preferred the review petition. A review petition, but it was not. But no decision was made by the in review petition. Then there was a scale promotion, my ladyship, of the plaintiff dated 21/3/1984, and this fact was not disclosed to the appellant. The appellant then seeks that he has made monetary loss for the period.
The entire case arises out of the scale promotion of 21/3/19. And the consequential relief for not granting promotion and not communicating this particular promotion. Is it not the fact?
This is the one fact. And the second, the plaintiff.
This was the suit. The entire calculation is arising out of this scale promotion.
It is in the Schedule A. The Schedule B, my ladyship, in which the bank has lien the pension account of the appellant. Recovered from the pension account. And secondly, my ladyship,
this is arising out of order of punishment. This Schedule B
is arising out of the
order of punishment.
order of the punishment.
So that particular order of punishment has attained finality.
Finality.
So what what do you have to say to the Schedule B? Where is your foundational fact with regard to Schedule B property? Where Schedule B amount? When did he attain the age of superannuation?
2003.
Sorry?
2003, my edition.
2003 he attained the age of superannuation. When did he file the suit?
In 2013.
2013. Suit was filed.
So,
Now, what is your foundation pleading with regard to Schedule B amount? Schedule B is quantified as how much?
4,75,000.
4,75,000. Where is this figure in your claim? 4,75,000.
My leadership in the page number 51.
No, first appeal you have to argue from the plaintiff. We do not see the trial court judgment. At the threshold, we do not see the trial court judgment. That will unnecessarily prejudice someone, isn't it?
She doesn't have
Very. अच्छा, ट्रायल कोर्ट का जजमेंट से क्या पढ़ेंगे? बताइए।
जो विटनेस है
नहीं, आप शेड्यूल बी का कहानी बताइए। शेड्यूल बी में क्या है आप?
further the witness has deposed that after the retirement he had opened a business in the name of MS Ranu Deshant and Services and from the Bank of India Adityapur branch.
Page number?
Page number 51.
51.
51 of the petition.
Yes.
Adityapur branch 1 CC account 3310. The credit limit of rupees 5 lakhs has been given, but without any reason. After 6 months, it was limited to rupees 3 lakhs, and due to non-cooperation of the defendant, his business was closed, leading to monetary loss. The chief manager, Adityapur branch, without any information, the fixed deposit was also broken, and also did not give the loan on the basis of his pension account on dated 8/3/2012. The defendant number 4 had also stopped the payment of rupees 1,40,000 out of the SB pension account of Kulyan branch. Account number this without any information has not been mentioned in his SB account on dated itna. The defendant number 4 had given an information that earlier CC account amount to be
Where is the
deposited.
reference of schedule B? There is no reference. Where is the reference of schedule B in your plate? You just annexed a schedule. Basic DA, PF contribution loss. It is basically basic DA and PF contribution loss, etc. It has got nothing to do with this loan. It is everything is revolving around the scale promotion dated 21/3/1980. The suit has been dismissed on account of limitation. Explain.
My leadership, we are saying that we are not in the knowledge that.
Where do you say? And what is the date of your knowledge?
based on 51 as per bank regulation,
No,
headquarter
you
had.
forget about the regulation. You said that you deny knowledge.
Hmm.
Where is the date of knowledge? And where is your denial of knowledge? पूरा plaint में कुछ नहीं है. फिर there is some, and the fact remains that there was so much of disciplinary proceedings against you, and merely because your name has been, you were granted promotion. Unless you join promotion, you are not entitled to any relief. सर्विस मैटर का बेसिक jurisprudence यही है. जब तक ज्वाइनिंग नहीं होता तब तक कुछ नहीं होता. 84 का प्रमोशन, 2003 का रिटायरमेंट, 2013 का सूट. कहाँ क्या explanation? There is no explanation whatsoever. Show me any explanation. Otherwise, I'll record that you have failed to show any explanation for the delay.
No knowledge.
Plain में भी कहीं नहीं. एक बार plain देख लीजिए, because दिखा नहीं. And if you are not able to cross the hurdle of limitation, matter ends. फिर क्या ही हम लोग क्या decide करेंगे? Just have a look at it. टू 2012 का लीगल नोटिस का कहानी बता रहे हैं. और कोई ऐसा ओरल एविडेंस भी नहीं. इनका डेट ऑफ रिटायरमेंट कहीं रिकॉर्ड पे आया है?
जी जी
कहाँ बताइए?
that is sorry, the 1st of July 2003.
कहाँ?
That is mentioned in
और आप तो रीट विट सब कर दिए थे, रीट किए थे, रीट टीएफडी हो गया था, सीएमपी भी आपका डिसमिस हो गया. द कोर्ट डिड नॉट एग्री टू रेस्टोर इट. उसके बाद जाके एक सूट फाइल कर दिया.
Tent में they have concealed that they had filed
आप
CL
प्लेन में
dated
आप कंसील
case.
और आपने भी तो वो डीएफडी का वो सब कहाँ एग्जिबिट कराया है? खाली बोलने से चलेगा? आपने कुछ नहीं एग्जिबिट, ऑर्डर भी नहीं एग्जिबिट कराया.
The last week was DFT. Then again
अरे
CMP
भाई
was
इट
filed.
वाज डीएफडी, आपके बोलने से थोड़ी होगा.
जी, जी.
जो ऑर्डर डीएफडी हुआ ये सब चीज एग्जिबिट कराना चाहिए था ना. ओरल एविडेंस में बोले हैं क्या?
तो इसमें आया है, ऑर्डर में आया है, सारे फैक्ट्स आए हैं.
नहीं है ना कुछ? Nothing. The case has been primarily decided on the point of limitation. So the only point for consideration would be as to whether the suit was barred by limitation. That's all.
लिमिटेशन में और नहीं होती है.
देखिए, लाइन. First appeal number 3 of 2022. Look at appearance then. This appeal has been filed against judgment dated 15/3/2021 and decree signed on 19/3/2021, whereby the civil judge, Senior Division Roman 2 at Saraikela, Khatsava, has dismissed the original suit number 3 of 2013, within bracket money suit number 3 of 2013. The plaintiff is the appellant before this court.
In para 21, your lordship, details of the case have come. In para 21 of the court judgment, the details of the CWJC have come. And that there was no settlement of that.
कौन सा पेज नंबर में पैराग्राफ
66.
तो आपका सबमिशन है ना
Submission.
by the learned counsel for the appellant has referred to the plate which was filed by the plaintiff and submits that the plaintiff was initially appointed as clerk under the defending bank and joined in the month of September 1964. He was promoted in the year 1971 and also transferred in the year 1973. And he had purchased a second-hand Fiat car by availing loan from defendant number 1. While the plaintiff was posted at Ranchi in the year 1981, he was served with article of charges relating to the period 21 to 1973 to 37 1978, alleging procedural irregularities and the said charge did not disclose any pecuniary loss to the defendant bank. However, charge number 6 was relating to purchase of second-hand car. In the domestic inquiry, the plaintiff was held guilty on the ground that he was the manager of the bank and was responsible for omission of the staff and was subjected to penalty of reduction of scale of 7 stages. The plaintiff filed an appeal before the appellate authority and the appellate authority by the order dated 3985 reduced the punishment from 7 stages to 5 stages. The plaintiff was again served another article of charges dated 24/5/1986, which was relating to certain advances of loan, certain advances by way of overdrawn to one of the customers, and in the said proceeding also the appellant was held guilty, and the inquiry officer of the earlier departmental proceeding was one of the witnesses in the second inquiry proceedings. And the case of the plaintiff was that it showed the vindictive attitude of the superior officers of the criminal. However, in the second disciplinary departmental inquiry, he was imposed punishment of reduction of scale by 5 stages by the order dated 23/10/1987. The plaintiff preferred appeal, and there was reduction in the matter of penalty by 2 stages, and the order of penalty was modified by reduction of scale by 2 stages. Against the appellate order, a review petition was filed, but the authority did not take care to pass any order in the review petition. The counsel submits that it was the case of the appellant. No, it was a case of the plaintiff that the plaintiff cannot be made liable for the acts of other persons. The learned counsel has further submitted that the entire relief in the plaint primarily revolved around the letter dated 29/3/1984, by which the plaintiff was granted scale promotion, but it was alleged that the superior officers of the defendant number 1 never disclosed this fact to the plaintiff and deprived him of availing the benefit, due to which the plaintiff suffered 59 lakhs rupees, loss of 59 lakhs rupees during the period from 1984 to 2003. She submits that the plaintiff attained the age of superannuation on 31st of July 2003. The detail of such loss has been mentioned in Schedule A to the plaintiff. The learned counsel further submits that apart from the monetary loss arising out of salary, etc., the plaintiff also suffered other legally payable dues on account of dearness allowance and PF contribution, and the same was quantified as rupees 4,75,000 and formed part of Schedule B to the plate. And thus the total monetary loss suffered by the plaintiff on account of non-communication of the letter of promotion dated scale promotion dated 29/3/1984 was to the extent of rupees 63,75,000. And the plaintiff, having suffered at the hand of the defendant, was entitled to the said amount and also compensation of rupees 5 lakhs. The plaintiff also suffered loss on account of reduction in CC limit when he started his own business after retirement. The learned counsel has submitted that the plaintiff had prayed for recovery of a total of rupees 68,75,000 on account of aforesaid heads and rupees 750,000 as recovery of 68,75,000 as per Schedule A and B of the plate. She has submitted that as per the plaint, the cause of action for the suit arose in the second week of May 2012 at Saraikela and Adityapur, when the defendant neither paid the amount nor replied to the legal notice sent by the plaintiff. On 16/3/2012, and upon receipt of legal notice, the chief manager of defendant number 4 verbally informed the plaintiff that defendant number 1 is not going to pay him. The learned counsel has submitted that the suit has been dismissed primarily on ground of limitation. Correct? Yes, I am. And has been held to be barred by limitation. She has submitted that the suit was filed after the plaintiff came to know about the grant of promotion to him, which was granted by letter dated 29/3/1984, and the learned trial court has not considered this aspect of the matter, and the period of limitation ought to have been counted from the date of marriage. Very after this, the learned counsel appearing on behalf of the respondents by opposing the prayer has submitted that the defendants had filed a written statement mentioning that the plaintiff had filed a writ petition before this court, being CWDC number 1080 of 2000 R for the same purpose for which the suit was filed, which was rejected by this court on 26/2001, which was dismissed on account of
Non-prosecution.
on account of non-prosecution on 26/2001, and even a petition seeking restoration of the writ petition being CMP number 470 of 2001 was dismissed on 9/8/2002. The Learned Counsel has also submitted that the suit itself was not maintainable, as stated in the written statement. He has also submitted that the fact that the plaintiff was subjected to 2 disciplinary proceedings and was punished by reduction of pay scale in each of the disciplinary proceeding is not in dispute, and the plaintiff is not in dispute, and therefore there was no question of grant of any scale promotion to the plaintiff by virtue of the decision of the year 1984. He has also submitted that
After a lapse of 25 years, Your Worship, they have come before the court. After a lapse of 25 years from the cause of action.
the Learned Counsel submits that the specific plea was raised that the suit was hopelessly barred by limitation, and the suit was filed after lapse of about 25 years from 1984, and after lapse of around 10 years from the date of superannuation.
Yes, sir. And Your Worship, after his retirement, he received 10 years pension and thereafter has raised the grievance.
That's right, 10 years.
Yes, Your Worship. After
And
receiving pension.
during the intervening period, the plaintiff also received the admissible pension.
Yes, sir. Your Worship, principle of estoppel will also apply in this matter. Because earlier CWJC was filed and thereafter Kent was filed. So,
The Learned Counsel has submitted that neither there is any explanation in the plaint with regard to the delay in filing the case, nor there is any evidence regarding the date of knowledge with respect to the promotion dated 29/3/1984. The Learned Counsel has submitted that the Learned Trial Court has fully considered the materials on record and by a detailed order has held that the suit was barred by limitation. Submits that the reasons given by the Learned Trial Court for dismissing the suit are reason based on materials on record, and there is neither any illegality nor any perversity in the matter of appreciation of evidence by the Learned Trial Court, and therefore the present appeal be dismissed. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that the foundational fact as narrated in the plaint that the plaintiff was appointed in the year 1964 and then he was given promotion in 1971, transferred in 1973, and that he was subjected to disciplinary proceedings twice. Firstly, by memo of charge dated 31/3/1983, where ultimately he was awarded the punishment of reduction of pay scale by 5 stages, and subsequently on by article of charge dated 28/5/1986, wherein he was ultimately granted reduction of pay scale by 2 stages, are not in dispute. It further appears that in the intervening period on (29/3/1984), the appellant claimed that he was granted scale promotion. It is further not in dispute that the appellant attained the age of superannuation in 2003 and was also granted the pensionary benefits, and the suit was filed in the year 2015. Upon perusal of the entire plaint, there is no averment with regard to the date of knowledge of the letter of promotion dated 29/3/1984, by which the plaintiff claimed to have granted scale promotion. The fact also remains that as per the order of punishment, twice he was held guilty and his scale promotion was reduced. From the perusal of the plaint, the cause of action is said to have arisen in the month of May 2012 at Saraikela, when the defendant neither paid the amount arising out of the so-called scale promotion dated 29/3/1984, nor responded to the legal notice. It is further not in dispute that the plaintiff never the plaint is completely silent with regard to the developments which had taken place after his the plaint does not disclose any date with regard to the date of knowledge of the letter of promotion dated 29/3/1984, which was scale promotion. This court further finds that this court further finds that as per the written statement, the specific point regarding limitation was taken, and it was also disclosed that the plaintiff had moved the High Court, in which the writ petition was dismissed for non-prosecution, and the restoration of the writ petition was also declined by the court. The plaintiff had the learned trial court framed as many as 17 issues for consideration, and in order to substantiate, which are as follows: in order to substantiate the case, the plaintiff examined himself as the sole witness and produced a large number of documents, the details of which is mentioned in paragraph 11 as under, इसको जरा quote कर देंगे, para 11. The defendant adduced oral evidences, oral evidence of only one witness who was examined as DW1, and no documentary evidence as such was adduced. The issue number 1, 2, 3, 4, 5, 7, 9 and 10 were taken up together by the learned trial court, and ultimately the learned trial court held that the suit itself was barred by limitation. Was hopelessly barred by limitation. The findings with regard to limitation has been given in paragraph 22 of the trial court judgment. The records of the case also reveal that the date of promotion? 29,384. What is the date of promotion?
Hmm, 23, 1984.
29,384.
23. Page number 4 of
29?
and it
Play
is
it with the 29.
and it is stated that the plaintiff got scale promotion by letter dated so and so dated 23 1984.
कहाँ लिखा है?
Your Worship, page number 31, running page 31. Page 4 of the judgment. In the middle, Your Worship.
नहीं वो गलत लिखा है। आप पेज नंबर 15 में देखिए जजमेंट के एग्जिबिट 2/1 इज 29,384. The learned trial court also considered the letter dated 29/3/1984 within bracket exhibit 2/1 by which the plaintiff claimed to have got scale promotion and recorded that the said letter intimated that his promotion result is kept in sealed cover and the same will be advised to him only after his case is decided. And thereafter major penalty dated 25/1/1985 was imposed upon the plaintiff. The learned trial court ultimately recorded a finding in that connection in page number 40 में. 40 में है ना, accordingly Mr. Mukherjee was intimated by the bank by letter dated. यहाँ तक का finding. पैरा 21 का last portion है ये. और paragraph 22. Paragraph 22 पूरा. In view of the aforesaid, the point for determination in the present cases as to whether A as to whether the suit was barred by limitation. B. If the answer to the aforesaid point of determination is in favor of the appellant, then whether the appellant was entitled for scale promotion. After going through the entire records of this case, including both the oral and documentary evidence, this court finds that there is no explanation whatsoever from the side of the plaintiff for not approaching the court for long years. Even after he attained the age of superannuation in the year 2003. And the suit was filed on in the year 2013. There is neither any pleading nor any evidence with regard to the date of knowledge of the plaintiff. Rather, the cause of action arose sometimes in the year 1984. But the plaintiff did not approach the court, and accordingly, this court has no doubt that the claim of the plaintiff was hopelessly barred by limitation. The learned trial court has given reasoned findings in connection with the point of limitation and has scrutinized the materials to come to a finding that the suit was barred by limitation, which ought to have been filed within 3 years from the date of cause of action. So far as the second point of determination is concerned, this court finds that the contents of the letter dated 29/3/1984 has been quoted in the implemented judgment itself. Which reads as follows in terms of paragraph 7 within bracket 3 of the motion policy framed under regulation 17 of Bank of India within bracket officers regulation 2979. Since there is a pending case of vigilance/department disciplinary action against the plaintiff, the result as to whether the plaintiff will be promoted or not is kept in sealed cover and will be advised of promotion result only after the case is decided, and ultimately by letter dated 17/10/1985, the punishment was awarded to the plaintiff with regard to reduction in pay scale, which was followed by another disciplinary proceedings and order of punishment of reduction of pay scale. this court is of the considered view that neither the appellant was entitled for promotion in terms of letter dated 29/3/1984. Was not entitled for promotion in terms of letter dated 1984, and consequently the relief as prayed for in through Schedule A and Schedule B, and also the claim of damages, which is primarily based on the claimed promotion, has rightly been rejected by the learned tribe. Both the points of determination are decided against the appellant and in favor of the respondents, and consequently, this court finds no reason to interfere with the claimed judgment and decree. This appeal is accordingly dismissed. Order by and large यही होगा. There will be more of some more, particularly that exhibit उसको हम quote करेंगे. उनका fixed
Yes. Item 1, second appeal 196.
बताइए.
Yes, I have gone through the order in the last appeal. But this appeal was heard by the order dated for 12th of June 2020. This appeal was heard and found substantial question to law whether the learned first appellate court committed gross illegality by not considering the records of 574 of 67 brought in the court of the first appeal, along with the petition filed in the order 41/27 of the Code of Civil Procedure in respect of its vote by the order dated questions the appellate court had mentioned that appropriate order would be passed in respect of such petition filed in the order 41/27 of Code of Civil Procedure, yet neither the order was passed with respect to the said petition. The order 41/27 of Code of Civil Procedure, not the same was considered without any findings. We have the defendants in the one of the plaintiff suit was delayed. There are two parts of suit property. In Schedule 1 Yellowship, the Khata number, land of Khata number 247,
plaintiff suit was decreed. No, first let me just see this question of law.
yes, I'm coming to it. What I want to say is that the suit was delayed for both on the whole Schedule 1 land. But the appellate court had partly allowed the appeal, and suit was dismissed with respect to 0.02 decimals. We have only challenged with respect to Khata number 247 to
With
447.
respect to 0.02 acres.
Yes, 0.2 decimals.
Okay. With respect to 2 decimals.
Yes.
Employing khata number,
It is Khata number 131,
khata number 131, plot number
281.
2810. The
It
suit
has
stood
been allowed.
dismissed.
It has been allowed. Appeal has been allowed, meaning that when to that extent the suit has been dismissed.
That's right.
They have not filed any cross appeal despite valid service of notice. They are not very
Yes.
matter.
Yes.
But the claim of plaintiff, Your Worship, that by virtue of a registered sale deed, the property in question was purchased was one by one.
Property in question is remaining portion. Remaining portion is which property? Khata number 131.
That property they claim they are claiming that property by virtue of Adia. both the property virtually they are claiming by virtue of Khatiyar. But so far as the property for which this appeal is to be heard, though title deed they have brought up, though they care.
We are only concerned with the
Yes.
question of office. उसके beyond आप कुछ हमको बात
What I want to say that at the appellate stage we file an application saying that the Khatiyar
आपका एप्लीकेशन का only to the extent केस नंबर 524 of 1967 ही हम देखेंगे
हाँ,
उसके beyond
तो
नहीं।
वो जो कि लैंड है, वो जो लैंड
ये केस नंबर 527 of 1967 क्या प्रोसीडिंग है?
ये एक 90 का CNT के अंडर का ऑर्डर
87 का जो ऑर्डर था ना,
ऑर्डर है जो जिससे वो कहते हैं कि करेक्शन हुआ है, दैट इज द बेसिस। लेकिन ये पर्टिकुलर
ये रिकॉर्ड की आपको क्यों जरूरत है?
नहीं, इसलिए कि वो लाइन इसमें लिखा ही नहीं हुआ, बतना ये बिलोंग टू सम मोदी
नहीं ऐसा
ऑर्डर
तो-
शीट में ऑर्डर
ऐसा तो आपका केस ही नहीं है।
नहीं, तो दैट व्हाट आई वांट टू से कि जिस केस नंबर के बुनियाद आप रिकॉर्ड जिस केस नंबर के बुनियाद पर आप क्लेम करते हैं जो खतियान में मेंशन वो उस रिकॉर्ड से है ही नहीं, उससे कोई लेना देना नहीं। आपको तो रिकॉर्ड ये आपको लाना चाहिए था, आप लाने के बावजूद भी ट्रायल कोर्ट ने एपीलेट कोर्ट ने इसे कहा कि हम इसको देखेंगे, तो इस पे तो कोई ना रिजेक्शन का ऑर्डर है।
नहीं रिजेक्शन देखिए, सबसे पहली बात है ये 1961 का था, आपका ड्यू डिलिजेंस तो एब्सोल्युटली मिसिंग।
हमारा पिटीशन
पिटीशन में नहीं है ना, आपका ऑर्डर पढ़िए, ऑर्डर में कोर्ट आपका यही था कि कोर्ट को अगर जरूरत होगा तो कोर्ट देखे।
हाँ, लेकिन कोर्ट को जरूरत है।
कैसे बोल रहे हैं कोर्ट को कोई जरूरत नहीं।
The order is on record. May kindly see the order. Last page को देखिए।
लास्ट पेज नहीं देखेंगे ना, आप लोग का आर्गुमेंट ये था कि कोर्ट को जरूरत होगी तो कोर्ट को ना, हमको जरूरत होगी तब
नहीं, जरूरत है इसका, इसलिए जरूरत है कि जो ये टोटल केस खतियान के बुनियाद पर इन्होंने लड़ा है। खतियान में ये केस का रेफरेंस
आप डिपेंडेंट थे ना,
हम डिफेंडेंट।
आपका क्या केस था?
हमारा कहना है कि ये लैंड हमें हुक्मनामा से मिला, हम अपना ये
नहीं वो नहीं, आप ये 67 का रिकॉर्ड से आप क्या कहना था? आप
हम ये कहना
आप बोल रहे हैं मिस्टर मोदी का किसी का था?
नहीं, ये रिकॉर्ड जो है इसमें इनका नाम ही नहीं लिखा हुआ है। आखिर जो आदमी क्लेम करेगा कि हमें इस पर्टिकुलर रिकॉर्ड से, इस पर्टिकुलर ऑर्डर से, इस पर्टिकुलर डॉक्यूमेंट से मेरा नाम चढ़ा है, तो नाम तो उसका होना चाहिए ना।
ये केस नंबर 524 ऑफ 1967 का आपके प्लेंट या रिटन स्टेटमेंट में कहाँ क्या जिक्र है?
हम लिखेंगे फ्रॉड है क्या?
आपने लिखा है कि ये एक्सपार्टे ऑर्डर था और फ्रॉडुलेंटली नोटिस सर्व करा के ऑर्डर कर दिया, यही आपका केस है।
लेकिन हुजूर,
लेकिन आपका ये केस नहीं है कि इस पर्टिकुलर केस में ये प्रॉपर्टी इन्वॉल्व था ही नहीं। दिस इज नॉट योर केस।
my lord, may kindly appreciate. I am producing the document and it
अरे
is a
भाई,
certified copy.
ऐसा नहीं होता है ना, यू हैव टू मेक आउट अ स्पेसिफिक केस दैट दिस पर्टिकुलर प्रॉपर्टी वाज नॉट इन्वॉल्व्ड इन दिस प्रोसीडिंग्स। ऐसा आपका केस ही नहीं है। और आप उसको दिखा के ये कहना चाह रहे हैं कि दिस प्रॉपर्टी वाज नॉट इन्वॉल्व्ड। अगर आपका ये प्लीडिंग है कि दिस प्रॉपर्टी वाज नॉट इन्वॉल्व्ड इन दिस केस,
नहीं, हमारा ये कहना है कि जिस रिकॉर्ड का ये जिक्र करते हैं उस रिकॉर्ड से इनका करेक्शन नहीं हुआ है। डिविजनल सर्वे ऑफ रिकॉर्ड्स
आप अपना प्लेन रिटन स्टेटमेंट पढ़िए, उसके बियॉन्ड तो हम आपको जाने नहीं देंगे। हाँ पढ़िए।
अगर इस चीज पर इसको वर्क किया जाए कि हमारा जब
बियॉन्ड प्लीडिंग तो कोई
बियॉन्ड
नहीं
प्लीडिंग नहीं कर रहे। हमारा जो कोई रिकॉर्ड पर अगर कोई मेरा डॉक्यूमेंट है जिसके बारे में इन्होंने कहा है कि हम इसमें कंसीडर
पहले क्यों
करेंगे
नहीं
या कुछ भी
produce
करेंगे,
किया?
तो ये इसको तो कम से कम रिजेक्ट ही कर देते।
नहीं रिजेक्ट नहीं, देखिए
एटलीस्ट हम
ऐसा
सुप्रीम कोर्ट
नहीं
में
है,
जाते।
ऐसा नहीं है। उन्होंने ये बोला कि दैट इज द
नहीं, ये
प्रोसीजर।
पॉइंट उन्होंने एक लाइन भी इस पर नहीं लिखा।
नहीं लिखा है कि हम
नहीं।
कंसीडर करेंगे, जैसे बोल रहे हैं आप।
नहीं, लेकिन लिखा नहीं, इन्होंने
नहीं,
जजमेंट में नहीं
लिखा।
लिखा, जजमेंट में
नहीं
नहीं।
जजमेंट में नहीं लिखा
हाँ,
होगा,
तो
लेकिन
फिर-
जजमेंट प्रोनाउंस करने में इनको कहाँ कोई दिक्कत
नहीं,
है?
जजमेंट
आप
pronounce-
हमको बताइए जजमेंट का कौन सा फाइंडिंग है
हाँ।
जिसके कारण से, मतलब कि इसके कारण से ये अफेक्टेड हो जाता है?
हाँ, बता। पहले हम इस पर
और पहले आप हमको प्लेन रिटन स्टेटमेंट दिखाओ कि भाई ये प्रॉपर्टी वाज नॉट कवर्ड बाय दिस पर्टिकुलर प्रोसीडिंग दिखाइए आप हमको। दिखाइए अपना प्लेंट और रिटन स्टेटमेंट में दिखाइए आपका क्या केस है। यू आर द डिफेंडेंट। पहले तो प्लेंटिफ का प्लेंट पढ़िए। पढ़िए। और कौन सा सूट कॉम्प्रोमाइज हो गया था?
तो वो दूसरा वाला है 02 वाला तो
Zero.
कोर्ट ने राइटली इसको नहीं दिया। ब्लेंड हम पढ़ते हैं।
एक चीज और,
ब्लेंड पढ़ते
एक चीज और आप देखिए, डिफेंडेंट नंबर 1 एंड 2 ने तो रिटन स्टेटमेंट तक नहीं पाई, ठीक है? तो डिफेंडेंट नंबर 1 या 2 को क्या राइट है एडिशनल एविडेंस देने का?
हैं। नहीं तो है
किसका? डिफेंडेंट नंबर 1 एंड 2 डिड नॉट फाइल रिटन स्टेटमेंट।
3 और 4 का है।
3 एंड 4 का है ना? 1 एंड 2 कौन कौन डिफेंडेंट इसमें अपीलेंट है जरा देखिए। 1 एंड 3 और दोनों जने मिलकर रिटन एडिशनल एविडेंस फाइल कर।
1 and 2 किया है इनका।
1 and 2 were debarred. They did not file written statement. 3 and 4 ने अपना written statement फाइल किया।
3 and 4 में तो शमसुद्दीन मियां तो अपीलेंट है ना।
उसके साथ देख तो दोनों जने मिल के ना एडिशनल एविडेंस दे रहे हैं, तो हम लोग उसको कैसे सेग्रीगेट करें? आप बताइए।
इनका इसमें हुजूर जो मेन क्लेम है इसको अप्रिशिएट करें। मेन इनका जो प्लेंटिफ का मेन क्लेम है वो खतियान के बेसिस पे है और खतियान में जो केस का रेफरेंस दे रहे हैं उसमें उनका नाम है ही नहीं। इट इज रिलेटेड विद समबडी। ये तो प्रेमा फेसी एक्सेप्ट हो जाना चाहिए। इसको इतना इनको रिजेक्ट करने की जरूरत ही नहीं। आखिर प्लेंटिफ को ना प्रूफ करना, हमें थोड़ा प्रूफ करना।
आप जरा देखिए ना इस पर्टिकुलर केस का जिक्र जो एडिशनल एविडेंस में है,
हाँ।
ये किस में आया है? प्लेंट में है, रिटन स्टेटमेंट में, कहाँ पर है?
प्लेंट में भी है, रिटन स्टेटमेंट में भी है।
बताइए केस
हाँ,
नंबर
प्लेंट- हम पहले
524।
प्लेंट पढ़ते हैं।
524
हम पढ़ते हैं।
आप पढ़िए।
इसमें देखा जाएगा इसमें 12(1) में ये क्या लिखते हैं।
आप खाली हमको पहले इस डॉक्यूमेंट का जिक्र दिखाइए, इस केस नंबर का जिक्र दिखाइए कहाँ पर।
हमने लिखा है जो the story of getting order under 87 from revenue officer against B.B. Jharia and in favor of B.B. Shaman Nisha is the result of इनका इंटायर क्लेम यही है कि
अरे भी कहाँ आप हमको दिखाई ना, इस केस नंबर का कहीं जिक्र भी है कहीं पर? इसको हम लोग कहाँ से लेकर? रिजल्ट ऑफ फ्रॉड में आप लोग का ये कहना है कि नोटिस बिना सर्व किए किसी और को सर्व किए ये सब कर दिए।
ये जो केस नंबर है ये ध्यान में लिखा हुआ है जो कि बेसिस ऑफ क्लेम।
हम नहीं जानते, आपके प्लेंट और रिटन स्टेटमेंट में कहीं जिक्र नहीं है, हम तो खोज रहे हैं, हमको नहीं मिल रहा, आप हमको दिखाई। पहले तो ये एडमिट करिए कि प्लेंट रिटन स्टेटमेंट में कहीं जिक्र नहीं है इसका। Tell us where is the discussion of this in plain and written statement? और ये देखिए
ये ट्रायल कोर्ट और एपेलेट कोर्ट के ऑर्डर में आया है ऑन द बेसिस ऑफ द एग्जिबिट्स 2 एंड एग्जिबिट बी जिसमें इसका डिस्क्रिप्शन और दिस इज द।
देखिए आपका कहीं भी केस ये नहीं था कि आपका प्रॉपर्टी इस पर्टिकुलर डॉक्यूमेंट से कवर्ड नहीं। आपका ये केस था कि दिस इज फ्रॉडुलेंट because the notice was not served, somebody had expired, it was an order against a debtor. This is what your pleading is.
My lord, may kindly consider the case of the plaintiff is that by virtue our name stands in the revisional survey of the laws of right. It is they are not disputing in the name of B.B. Jharia. We claim from her. My lord, their claim is that by virtue of this proceeding, actually there was a change in the name of their name by khata.
आप एक बात बताओ, and evidence which has not been produced in spite of your knowledge.
The evidence has been produced.
Just a moment, and evidence which has not been produced in spite of your knowledge and due diligence at relevant point of time. The only thing the court has to see as to whether the court could have decided the case on the basis of materials on record. And if the court finds that the court cannot decide the case on the basis of materials on record, then only the court, it is absolutely in the discretion of the court. You just tell us that the court could not have decided the case in absence of the document, please satisfy.
Yes. My lord, may kindly appreciate the entire basis of claim is Khatiyan. And in Khatiyan, my lord, this case is mentioned. My lord, and it is the basis of this case only. They claim that the khata has been entered in their name. I am now, my lord, producing the original copy of my lord, that order, which does not relate to them.
If you are producing that original copy of that order which does not relate to them, then under such circumstances there has to be some foundational pleading to that.
My lord, the foundational pleading, your lordship,
Yes.
on both the part of the on both parties, your lordship, that under the proceeding under section 87 this correction was made. Now the question, your lordship, there must be some proceeding. It was their duty to give the details of those proceedings. But as because they did not give, the my lord, details were in the Khatian itself. Now, my lord, the Khatian.
You are trying to make out a different case altogether.
No, no, not at all.
You tell me from your written statement that this particular rectification had nothing to do with this particular property. You show me from your written statement. In absence of that pleading, how do we take this evidence?
No, pleading is regarding 87.
It says that it is fraudulent, notice was not served, it was passed against a dead person. Show me that even if this particular order is taken into consideration, it has nothing to do with this.
Not value. If the order does not relate to the parties, then how they can claim on on such a order, my lord, a Khatian can be prepared and which can have a sanctity of presumption.
You see, your entire case is not revolving around that.
No, it is revolving around
Show
both the
me,
parties.
I'm asking you, read your written statement and show me that your case was revolving around this plea. That this particular order of rectification had nothing to do with the property involved in this case. Show me one line.
But a story of getting any order under 87 from the revenue office against the Bibi Jharia and in favor of Shamil Nisha is result of fraud. These defendants number 3 and 4 on Mother Jharia was never served any notice from the revenue court, and these plaintiff clandestinely obtained and managed to suppress the actual service of notice and get order of portion behind the back of the defendant. Mosmat Jharia, who was dead by this time, the order was passed, and against the order, the dead person and the defendants, being innocent and simple persons, should not know that what clandestine was going on played by the plaintiffs to obtain either the modified intentions to other of the land. The defendants never know of such order under section 87 of CNT Act against the Mosmat Jharia or any other having passed with plaintiffs has not been given revenue suit numbers also. These defendants reserve their right to reply in detail and explain to the Court of Justice as to how these plaintiffs have fraudulently managed to obtain the order and substantially against a dead person, Mosmat Jharia. The plaintiff have also very clandestinely omitted to mention as to how Bibi Samia Nisha had acquired the virtue of the whole document as it was a Ganmajarua खास land of the excellence. हमारा कहना स्पेसिफिक था कि आपने कोई नंबर नहीं दिया, कुछ नहीं दिया, और जो नंबर एक्चुअल में खतियान में है वो आपसे रिलेटेड
नहीं बोले हैं आप रिटन स्टेटमेंट में कोई सेंटेंस पढ़ने की कोशिश मत करें। आपके रिटन स्टेटमेंट में ये केस नहीं है कि बाय दिस अगर आपका इस पर्टिकुलर ऑर्डर से आपका इस प्रॉपर्टी का कोई लेना देना नहीं था, वन स्टेटमेंट इज सफिशिएंट that this particular order has got no relevance for this case. इसका रेक्टिफिकेशन से कोई लेना देना नहीं, ऐसा आपका केस नहीं।
लेकिन इनका तो केस यही है कि ये इसी बुनियाद पर क्लेम कर रहे हैं।
आपको अपना डिफेंस मजबूत करना था ना, एडिशनल रिटन स्टेटमेंट।
हमारे लिए हमें अपना डिफेंस मजबूत करना चाहिए, लेकिन it is the duty of the plaintiff to prove his case and prima facie that by virtue of that document वो लैंड वो उनसे रिलेटेड है ही नहीं, उसमें मोदी का नाम है, तो जब मोदी का नाम है तो इनका कैसे करेक्शन हो सकता है उस ऑर्डर से? तो वो जो ऑर्डर है जो खतियान में लिखा हुआ है जिसके बुनियाद पर ये क्लेम करते हैं, इन्होंने अपना कोई टाइटल डीड नहीं दिया, जो डॉक्यूमेंट के बुनियाद पर ये क्लेम कर रहे हैं वो डॉक्यूमेंट इनसे रिलेटेड नहीं है, उसका हम ओरिजिनल ऑर्डर लगा रहे हैं। ये चीज़ को कोर्ट को देखना चाहिए था कि हाँ, उनको बल्कि इनको पूछना चाहिए था कि हाउ यू आर रिलाइंग, हाउ दीज रिसाइटल्स यू आर रिलाइंग, हाउ दीज हम तो इसको रिपोर्ट कर दी, प्रिजम्पशन ऑफ करेक्टनेस होता है खतियान का, आई डू एग्री टू दैट प्रोपोजिशन, बट व्हेन आई एम प्रोड्यूसिंग द ओरिजिनल ऑर्डर which does not relate with them, then how despite that how the presumption is not being rebutted? कम से कम इसको मेरा रिजेक्ट तो कर देते, I could have gone to superior court. Your Lordship may kindly see the law.
Right. it should be found necessary to remove it. जो प्लास्टिक थोड़ा सा देख रहे हैं, if additional evidence is found to have important bearing on the main issue, or found to be necessary to remove any lacuna in evidence and for clearing any doubt for pronouncing judgment, and
My lord,
required in interest of justice, it may be.
My lord, may kindly read para 49.
Ready?
An application under Order 41, Rule 27 is to be considered at the time of the hearing on merits, so as to find out whether the document or the evidence sought to be adduced have any relevance bearing on the issues involved. The admissibility of additional evidence does not depend upon the relevancy to the issue on hand or the fact whether the applicant had an opportunity for adducing such evidence at the earlier stage or not, but it depends upon whether or not the appellate court requires the evidence sought to be adduced to enable it to pronounce judgment or for any substantial cause. The true test is therefore whether the appellate court is able to pronounce judgment on the material before it without taking into consideration the additional evidence sought to be adduced. Such occasion would arise only if on the examining the evidence as it stands the court to come to conclusion that some inherent lacuna or defect becomes apparent to the court. While Arjan Singh versus Kartar Singh and Natha Singh versus Financial Commissioner Taxation, in Purushottam Thakur versus Lal Mohar Thakur, it was held. The provision of Section 107 Civil Procedure Code as elucidated by Order 41 Rule 27 are clearly not intended to allow a litigant who has been unsuccessful in the court to patch up the weak parts of his case and fill up the omission in his appeal. Rule such and such, it may be well a defect will be pointed out by the party, or the party may hope to the court to apply the defect, but requirement must be requirement of the court upon its appreciation of evidence as it stands. Whenever the court adopts this procedure, it is bound by the Rule 27 to record its reason for doing so, and under 29 must specify the point to which the evidence to be confined and the recorded proceeding to be to the point so specified. The powers so conferred upon the court by the court ought to be sprangly exercised, and one requirement at least of the evidence to be adduced should be that it should have a direct and important bearing on the main issue in the case. In Arjan Singh versus Kartar Singh, this court held, if additional evidence was allowed to be adduced contrary to the principles governing the reception of such evidence, it would be case of the improper exercise of discretion, and additional evidence so brought on record will have to be ignored, and the case decided as if it was non-existent. The order allowing appellant to call additional evidence in dated 8/17/1942, the appeal was heard on 24/4/1942, and thus there was no examination of evidence on record, and a decision reached that the no evidence had disclosed a lacuna which would quote the required to be filled up by pronouncing judgment. Thus, from the above, it is clear that an application for taking additional evidence on record at the appellate stage, even if it is filed during the pendency of appeal, is to be heard at the time of the final hearing of appeal at a stage when, after appreciating the evidence on record, the court reaches the conclusion that additional evidence was required to be taken on record in order to pronounce judgment or any other substantial ground. In such case, application for taking additional evidence on record has been considered and allowed prior to hearing of the appeal. The order would product of a total, complete non-application of mind as to whether such an evidence is required to be taken on record, the judgment or not, remains inconsequential, indisputable, and liable to be ignored. My lord, my humble submission before your lordship. Let appellate court rightly, my lord, observe that I will be filing appropriate orders at the relevant time. When the matter was being
Who
heard,
will be filing appropriate orders at the relevant time?
lordship may kindly see the order. May kindly see it. 25th of February 2019. Last question, Your Lordship.
Yes. Please read it. Produce the record.
With the record, it appears from record that the appellate state, the appellants have filed this petition for making the documents mentioned in the petition as exhibit by additional document. In my opinion, at this stage, without hearing final arguments of the parties, it cannot be said that the document mentioned in the petition, if taken on evidence and marked as exhibit, will enable the court to pronounce the judgment. At the time of final hearing of the appeal at this stage, when after appreciating the evidence on record, court reaches to conclusion that the document mentioned in the petition is required as an additional evidence to be taken on record, pronounce the judgment, then that time appropriate orders will be passed in this regard. Not a single line in the entire judgment, my lord will find that it is not required, or without it the judgment can be passed. No, there is not a single line, and it is such a material document that the basis of claim is
So that is why I'm hearing you that what material does it have? Because the court has pronounced the judgment and court did not find any difficulty in pronouncing
you
it.
cannot find difficulty as because it did not consider it, despite your observation.
Difficulty तो difficulty होगा तब देखेंगे नहीं होगा तो नहीं देखेंगे.
डिफिकल्टी तो इसमें पूरा है.
Difficulty कहाँ है?
नहीं पूरा जो जो ऑर्डर जो हम जिसके बुनियाद पर वो उनका जो इंटायर क्लेम बेस करता है, जो उनसे रिलेटेड ही नहीं.
आप जो ये बात बोल रहे हैं कि जिसके आधार पे उनका पूरा क्लेम बेस करता है वो उससे रिलेटेड नहीं है. It is not based on the pleading. Can any additional evidence be adduced which is beyond the pleadings?
My lord, they are relying on an 87 proceeding. I am producing the original order, my lord, of 87 proceeding, which is mentioned in the Khatiyan itself, by virtue of which the
खतियान कौन सा exhibit है?
दोनों exhibit 2B, exhibit BB.
दिखाइए.
हाँ.
दिखाइए खतियान दिखाइए.
नोट कॉलम देखा जाए.
Exhibit 2 से चलेगा?
Exhibit 2 देखा. My lord will find 98 BB Jhalia. Name of BB Jhalia.
ऐसा नहीं पता चला.
BB Jhalia.
Exhibit 2 ना.
2 देखा. Exhibit 2 is certified copy of the देखा जाए. हमारे पास certified copy.
नहीं इसमें से दिखाइए. अब आपका रिकॉर्ड से नहीं दिखाइए. पढ़िए क्या लिखा है?
मुकदमा नंबर 424 सन 1967 CNT एक्ट धारा 87 के अनुसार खाता नंबर सच एंड सच में दर्ज समझा जाए. This is the ground they are taking. My name is there in the BB Jhalia.
पूरा पढ़िए ना।
पूरा पढ़। मुकदमा नंबर 524 सन 1967 CNT की धारा 87 के अंतर्गत धारा के आदेशांश खाता नंबर 98 में से तीसरा नंबर सच एंड सच को 247 में दर्ज समझा जाए। हम तो 524-67 का डॉक्यूमेंट दे रहे हैं कि ये डॉक्यूमेंट आपसे रिलेटेड नहीं है, इट इज रिलेटेड विद बॉडी, इट इज अ मटेरियल डॉक्यूमेंट। कम से कम मेरा रिजेक्ट तो करते, कहते कि नहीं आप आपका इससे को दे यार, उतना ही नहीं है। एग्जिबिट बी में भी सेम और इन्होंने इसको देखा भी, समझा भी, सब कुछ किया, इसको देखे ही नहीं कि हाँ इस ऑर्डर को भी लाया गया। आज देयर वाज ए प्रीडिसेसर्स ऑब्जर्वेशन कि हाँ हम देखें।
कहाँ है आपका एडिशनल एविडेंस दिखा
जी
एडिशनल एविडेंस कहाँ है?
वो आपका मेमो ऑफ अपील
मेमो ऑफ अपील में लगा दिए हैं।
लास्ट पेज है।
यही एग्जिबिट आप कराना चाह रहे हैं?
हाँ एक एग्जिबिट कराना चाहते हैं।
पढ़िए पढ़िए।
वो है उसी में लिखा हुआ है, वो दिखा था उसमें बॉडी
आपके पास नहीं है?
एक तो फाइनल कॉपी हमने दे दिया था, एडमिशन हुआ था उसी दिन दे दिया।
फाइनल कॉपी में
सर्टिफाइड का फोटो वो तो बाकी रिकॉर्ड में होगा, लेकिन है उसमें मोदी का नाम है, पढ़ देते हैं, वतन मोदी या समथिंग है। मेरा क्लेम यही है कि हम लोगों को मोदी से हमको हुक्मनामा मिला, गोपिंदिया एंड अदर्स के नाम से, जो कि इन्होंने दैन मोहर में बीबी झरिया को दिया, ये प्लीडिंग है। इट इज अ मटेरियल लॉ, इट हैज टू बी एटलीस्ट इनको रिजेक्ट तो करना ही चाहिए था कि हाँ हम इसको नहीं देंगे। हम सुप्रीम कोर्ट जाते हैं, मेरा राइट टू जुडिशियल, और आपने एक लाइन भी नहीं लिखा जजमेंट।
हमारे पास तो ये डॉक्यूमेंट नहीं है, ठीक है? आपने जो लगाया है वो अपनी जगह है, लेकिन हमारे रिकॉर्ड में ये डॉक्यूमेंट नहीं है, इट इज नॉट देयर। इसको दिखाइए, पढ़िए जरा, इसको लेके पढ़िए। ना तो इसका टाइप कॉपी फाइल किया हुआ है, जिस तरह से लिखा हुआ है बिल्कुल भी नहीं बना।
न्यायालय सर्वेंट सेटलमेंट ऑफिसर हजारीबाग, केस प्रकार 90 CNT, केस नंबर 524 बटन मोदी वर्सेस जैन नायक। दिस पिटिशन has been filed under section 90 of CNT Act. Registered it Sri D. Das ASO will kindly report after the verification of records about the mistakes raised by applicant. Fixing 14/6/1968. The petitioner Bhutan Modi does not press this petition as this name has already been recorded of in the petition is rejected as not pressed. 524-67 का जो
नॉट प्रेस से क्या हुआ?
नहीं 524-67 का रिकॉर्ड ये वतन मोदी और जैन नायक के नाम से। अगर मान लीजिए आप क्लेम करते हैं कि हमने फाइल किया और इस पर्टिकुलर प्रोसीडिंग के बुनियाद से वो खाता इस खाता में रिकॉर्ड माना जाएगा।
कोई केस इस तरह से विथड्रॉ हो गया, इट इज नॉट एन एडजुडिकेशन, इट इज नॉट अ रेक्टिफिकेशन, कुछ नहीं है।
नहीं तो कम से कम हम तो दे रहे हैं ना कि इसमें किसके नाम से केस रिकॉर्ड है।
इससे क्या होगा?
केस रिकॉर्ड
ऐसे नहीं होता। कौन कौन पार्टी है, क्या क्या है,
लिखा है।
नेक्स्ट पेज में क्या लिखा हुआ है? कुछ नहीं है।
पार्टी का नाम लिखा
It was never your case that this property is not recorded, this particular document is
अच्छा
not.
इसके साथ इसका एप्लीकेशन भी लगा हुआ है। भूटान मोदी सच एंड सच बनाम दरखास्त छोटा नागपुर 90 छोटा नागपुर CNT। ये दरखास्त ये जो केस का जो हवाला ये दे रहे हैं वो सेक्शन 90 में फाइल हुआ था, इवन नॉट इवन इन 87 में भी नहीं फाइल हुआ। तो ये डॉक्यूमेंट के बुनियाद पे, इसके बुनियाद पे जो उनका हमारे से उनसे कैसे संबंध है?
ये केस नंबर कहाँ का है?
ये हजारीबाग
केस नंबर सेक्शन 87 और सेक्शन 90।
सेक्शन 90
सेक्शन
सेक्शन
90
87 के बाद 5 साल के
87 के बाद 90 होता है।
90
होता है।
हाँ।
और ये 90 का ऑर्डर आप लेके आना चाह रहे हैं?
नहीं, 90 का ऑर्डर हम ये का हमारा सिंपल प्लीडिंग यही है कि जिस केस के बुनियाद पर ये राइट क्लेम करना चाहते
आपका
हैं।
सिंपल प्लीडिंग ऐसा नहीं है। आपका सिंपल प्लीडिंग ऐसा है कि ये जो जिस केस के बुनियाद पे बोल रहे हैं वो फ्रॉडुलेंट है, एक्स पार्टे है, बिना नोटिस सर्व किए है। आपका ये प्लीडिंग नहीं है कि उसका इस केस से कोई लेना देना नहीं। That is not your case.
डॉक्यूमेंट देखने से ही पता चलता
नहीं तो आपको तो अपना रिटन स्टेटमेंट अमेंडमेंट करना चाहिए। आपने तो नहीं किया।
डॉक्यूमेंट
अगर मान लीजिए कोई नया चीज आपके पर नजर में आ रहा है और मान लीजिए उसका फाउंडेशन प्लीडिंग आपके रिटन स्टेटमेंट में नहीं है तो आप अमेंड नहीं करिएगा अपना रिटन स्टेटमेंट
इसमें
and you will need evidence as per your own free will.
नो एडिशनल स्टेज अपीलेट स्टेज पे एडिशनल एविडेंस को हमने लाया और अब ये कोर्ट को देखना है क्योंकि इसमें कोर्ट का डिस्कशन है कि ये पर्टिकुलर डॉक्यूमेंट इतना मटेरियल डॉक्यूमेंट है कि नहीं। बहुत से स्टेजेस है।
भाई कोर्ट ने इतना इत्मीनान
नहीं,
से
इसमें
अपना
तो
ऑर्डर
मैं-
पास कर
इसके-
दिया,
इस-
उनको कोई
इस- इस
जरूरत ही
document-
नहीं पड़ी।
इस डॉक्यूमेंट के बारे में
आप हमको बोल सकते हैं कि इस डॉक्यूमेंट के बिना कोर्ट प्रोनाउंस नहीं कर सकता था
अगर
जजमेंट,
इसको कंसीडर करते तो ये जजमेंट नहीं पास करते।
वो अलग बात है। तो आप क्यों नहीं प्रोड्यूस किए? बात ये
produce किए।
कैन यू से दैट दिस जजमेंट कुड नॉट हैव बीन प्रोनाउंस्ड विदाउट दिस डॉक्यूमेंट?
I can say so.
हाउ कैन यू से?
I can say so because जब खतियान इनका फाइंडिंग देखा जाए क्या फाइंडिंग है खतियान, जब ये डॉक्यूमेंट क्लियरली शो कर रहा है कि ये इनका इससे कोई वही नहीं है, इससे कोई मतलब नहीं है, तो
आप यही आपका एडिशनल एविडेंस।
और ये इसमें देखा जाए तो इसमें क्या लिखा है। ये भी लिख देते कि नहीं इसका कोई जरूरत नहीं, इतना तो लिखा है।
दिस केस वाज डिसमिस्ड एज नॉट प्रेस्ड।
हाँ, जब इनका केस है ही नहीं, इनसे रिलेटेड ही नहीं है, कैसी जो नंबर दे रहे हैं वो भी रिलेटेड नहीं। अच्छा, इसका ये जवाब दिए थे, ये जो ऑर्डर हुआ था एडिशनल एविडेंस वाला, उसमें उन्होंने रिप्लाई दिया। रिप्लाई होने के बाद एक ऑर्डर हुआ था, उसमें कोर्ट ने कहा था कि
तो
ठीक
वो
है।
रिप्लाई और वो सब आप एग्जिबिट कराना चाहिए।
नहीं, रिप्लाई नहीं, हम खाली इसको ऑर्डर भी अगर ये हो जाए, अगर ये ऑर्डर भी अगर इसको कोर्ट अगर इसको कंसीडर करे तो इससे प्रेमा फेसी अपीयर हो रहा है कि इनसे ये मामला रिलेटेड नहीं। 524 67 से तो इनसे रिलेटेड नहीं। तो जब इनसे रिलेटेड ही नहीं है तो इसके बुनियाद पर इनमें 98 और 247 का जो क्लेम कर रहे हैं राइट, वो इनको अवेलेबल नहीं है। ये वाशिंग में काइंडली सी डिफाइन है। Whether the plaintiff have got right title, interest and possession over the suit land of
नहीं, आप हमको इस डॉक्यूमेंट का जिक्र दिखाइए कहाँ, where it is discussed, where this case number is discussed.
वो बताओ, ट्रायल कोर्ट से दिखाते हैं।
ट्रायल कोर्ट से।
Malot may kindly see page, internal page 8 of the trial court judgment, running page 48. In support of title, my lord, मैं can't see. They are claiming title by virtue of these documents. They have not produced any.
Para 48.
In support of their title, over the suitland plaintiff have produced certified copy of Khatiyan of Khata number 98 Exhibit 2 and certified copy of Khatiyan of Khata number 131. From peruse of Exhibit 2 regarding the Khata 98 as note has been given by the Assistant Settlement Officer Hazaribagh. There is a missed case 527 of 1967 under 87. It has been ordered that the land of plot number 2447 and 2452 of Khata number 98 is being recorded in Khata number 247. Similarly, खाता नंबर 2 का ये तो खाली इससे ये वाला तो अभी हमको जरूरत नहीं है।
आप हमको ये बताइए जो आप अभी एडिशनल एविडेंस की बात कर रहे हैं,
वो तो
that is
उसका
an
नंबर
order
है।
under section 90.
But they are saying that it is under 87.
अरे भाई उसके वो तो एग्जिबिट ही नहीं कर रहे हैं, आप उसको एग्जिबिट कराना चाहते
वही
हैं। इज इट योर केस कि वो नहीं, वो ऑर्डर तो 90 में हुआ था, 87 में नहीं हुआ था?
ये हम कहना चाह रहे हैं कि इसमें जब जो केस नंबर जो जिससे क्लेम है, जिसका कि रेफरेंस है खतियान,
अरे भाई आप इसको दूसरी तरह से समझिए, ठीक है? WPC नंबर 1 of 2024 एंड LPA नंबर 1 of 2024 अलग-अलग प्रोविजन का ऑर्डर है। उसके बाद आपको बोलना पड़ेगा ना,
इतना कोइंसिडेंस नहीं होता है।
इतना कोइंसिडेंस ये
नहीं
नहीं चलेगा ना। दैट इज एन ऑर्डर अंडर सेक्शन 90। ऐसे नहीं चलेगा। आपको अपना बिना रिटन स्टेटमेंट अमेंड किए हुए आप इस तरह का एविडेंस नहीं दे सकते हैं कोर्ट में। दैट इज एक्सपेशाई एन ऑर्डर अंडर सेक्शन 90। नो आई एम एप्रिशिएटिंग, ऐसे नहीं
हमारा जो प्लीडिंग है, हमारा प्लीडिंग बहुत स्पष्ट है।
आपका प्लीडिंग ऐसा कहीं नहीं है कि इस पर्टिकुलर केस नंबर से जो है आपके इस केस का कोई लेना
हम
देना
बता रहे हैं, हमारा प्लीडिंग ये है कि हमने मोदी
अच्छा, कोई तो जजमेंट सुप्रीम कोर्ट जाना चाहिए ना।
नहीं, हम दूसरा चीज बोल रहे हैं, सुप्रीम कोर्ट की बात नहीं कर रहे थे। हम कह रहे थे कि हम मोदी से हमने हुक्मनामा लिया।
देखिए, आपने एक ऑर्डर सेक्शन 90 का प्रोड्यूस किया एज एडिशनल एविडेंस।
ये इस लिहाज से हमने ये ऑर्डर प्रोड्यूस किया कि ये केस जिस केस के बुनियाद पर कम से कम वो एंट्री इनके नाम से रिकॉर्डेड मानी जा रही है,
कैसे मानेंगे?
that not relate it।
कैसे मानेंगे?
अब देखा जाए, नोट में देखा जाए, यही क्लेम ही है।
और इसमें सेक्शन 87 क्लियरली लिखा हुआ है।
लिखा हुआ।
तो फिर आप सेक्शन 90 का ऑर्डर प्रोड्यूस करके आप कैसे क्या प्रूफ
हम
करना
नहीं
चाहते
कहना चाह रहे हैं कि जो केस नंबर 524 ऑफ 1967,
हाँ।
ये केस नंबर का रेफरेंस इसमें जो जिसके बुनियाद पर क्लेम करते हैं, that does not relate to them।
अरे भाई आप इसको समझिए, ये सेक्शन 87 का ऑर्डर, अगर ये 527 अगर सेक्शन 87 में ऑर्डर हुआ होता तो हम बस सोचते भी कोई चीज। जो आप ऑर्डर लगा रहे हैं वो केस नंबर वही है, साल वही है, लेकिन सेक्शन 90 का ऑर्डर है।
ना कोइंसिडेंस
ना कैसे कोइंसिडेंस नहीं होता है? आप हमको बताइए, केस नंबर 1 WPC 1 ऑफ 1997 एंड LPA 1 ऑफ 1997 होगा कि नहीं होगा? 100%
ना होगा।
और अगर आप WPC 1 ऑफ 1997 की बजाय LPA नंबर 1 ऑफ 1997 का अगर आप ऑर्डर लगा के प्रूव करना चाह रहे हैं कि WPC का जो एंट्री है सो गलत है, तो ये कैसे चलेगा? और ना ही आपका ये फाउंडेशनल केस है।
नहीं, केस तो हमारा है कि उन्होंने फ्रॉड किया और हमारा प्लीडिंग से सपोर्ट हो रहा है। ये डॉक्यूमेंट जो है ये मोदी के नाम से है और हमें मोदी से हुक्मनामा मिला है, जो कि हमने मेरा एग्जिबिटेड डॉक्यूमेंट, मेरा एग्जिबिटेड डॉक्यूमेंट। कम से कम इसमें एक लाइन ये लिखते तो कि नहीं हमको जरूरत नहीं है, ये कोई डॉक्यूमेंट नहीं है, ये इसका कोई मतलब नहीं है। कम से कम ये चीज तो इनको लिखना है। इंटायर केस इसी चीज पर हिंज कर रहा है कि और इन्होंने कोई अपना टाइटल डीड भी नहीं दिया, खतियान से टाइटल क्लेम कर रहे हैं। हम उस केस का रेफरेंस लगा रहे हैं, उस केस का हम नंबर दिखा रहे हैं कि ये इससे रिलेटेड नहीं है। तो फिर इस चीज को अच्छा
और आप देखिए जो ऑर्डर आप लगा रहे हैं, दिस इज द कोर्ट ऑफ सर्वे सेटलमेंट ऑफिसर,
हाँ वो होने का है वही
Right?
हाईलाइट
और इसमें लिखा हुआ है गिवन बाय असिस्टेंट सेटलमेंट ऑफिसर,
किसमें लिखा हुआ
ये जो आपका ऑर्डर है, ठीक है। सर्वे सेटलमेंट ऑफिसर एंड असिस्टेंट सेटलमेंट ऑफिसर आर वन एंड द सेम,
नॉट
अलग है ना। तो फिर अथॉरिटी भी अलग है, केस नंबर भी अलग है, प्रोविजन ऑफ लॉ भी अलग है, दोनों को हम कैसे कोरिलेट करके आपको, इसका कोई पर्पस ही नहीं है, कोई मतलब नहीं।
नहीं इसमें तो सिर्फ ये लिखा हुआ है कि 524 67 सीएनटी के 87 के आदेशांश, इसमें तो कोई ऑर्डर शीट में ये चीज तो नहीं
नहीं,
लिखा
ये जो इसमें लिखा हुआ है ऑर्डर में, जो जजमेंट में लिखा हुआ है
इसमें?
उसकी बात कर रहे हैं, जो जजमेंट में लिखा हुआ है।
कौन सा ऑर्डर
In support of the title over the suit land, plaintiffs have produced certified copy of Khatiyan and certified copy of Khatiyan subject from very perusal of exhibit regarding land of Khatiyan. It has a note has been given by assistant settlement officer.
ऐसा लिखा हुआ तो नहीं
Signature होगा
नहीं
उनका?
नहीं देखा कहाँ नोट में तो सिर्फ लिखा है 1967 सीएनटी धारा के आदेशांश, नीचे में दस्तखत कर रहे हैं सहायक बंदोबस्त।
तो फिर है ना, तो अथॉरिटी अलग है, केस नंबर अलग है, इसका कोई, इसको आप कोरिलेट नहीं कर पाए हैं, इट इज नॉट पॉसिबल, दिस हैज गॉट नो रेलेवेंस एट ऑल। Second appeal number 196 of 2020. In spite of service of notice, nobody has entered appearance on behalf of the respondents. Correct? Heard the learned counsel appearing on behalf of the appellant. This appeal has been was admitted for final hearing by the order dated 12/6/2023 after framing the following substantive question. The learned counsel for the appellant has referred to the memo of appeal and has submitted that an order dated 20 that at the appellate stage additional evidence was led on behalf of the appellants who were defendant number 1 and 3, who were defendant number 1 and 3 in the title suit, to bring on record by way of additional evidence the certified copy of order sheet in case number 524 of 1967 of Survey Settlement Office of Hazaribagh.
May I see who is the signatory of that order?
खाली ऐसे ही लिखा हुआ है, ऊपर लिखा हुआ है ऑफिस ऑफ सर्विस सेटलमेंट।
इनका पिटिशन भी दिया गया है, पिटिशन
देखिए आपको क्या देखना है, तो ऐसा उर्दू में लिखा हुआ है कि कुछ समझ नहीं आ रहा।
कैसी लैंग्वेज
कैसी language?
एसओ को इन्होंने जांच करने के लिए कहा. This petition has been filed under section 90 of CAT Act. Registered CBD ASO will kindly report after the verification of records about the mistakes alleged by the applicant by fixing 14/6/1968 at Sariakan. The petitioner Bhutan Modi does not press this petition as this name has already been recorded in the record of such and such. दस्तखत किए हैं 14/6/2008. नीचे मुझे कुछ लिखते हैं. The notice was issued.
The Learned Counsel for the appellant, while referring to order dated 25/2/2019 passed by the Learned Appellate Court, has submitted that the certified copy of the order sheet in case number 524 of 67 of Survey Settlement Office of Hazaribagh obtained from the record room Hazaribagh was filed, and the learned court specifically recorded that at that stage the document cannot be considered, but it will be taken, but at the time of final hearing of the appeal and after appreciating the evidence on record, if the court reaches to the conclusion that the document mentioned in the petition is required as an additional evidence to be taken on record to pronounce the judgment, then at that time appropriate order will be passed in this regard. The Learned Counsel has submitted that the appellate court judgment does not refer to the certified copy of the order sheet in case number 524 of 1967 of Survey Settlement Office. He has submitted that a copy of the document.
No, that case has been referred, but in the name of Modi, that is not right. So far as 524.
Absolutely. The Learned Counsel for the appellant has also submitted that the document which was sought to be adduced as additional evidence has been filed along with a memo of appeal.
No, it has not been filed. At the time of the admission, I have given this document.
ये इसके साथ नहीं लगाए हैं आप,
लेकिन कोर्ट ने अपने रिकॉर्ड में दे दिया.
रिकॉर्ड में दिया है. Was filed during the course of admission and has been annexed along with the records of this case. He has referred to the said documents sought to be adduced by way of additional evidence and has submitted that the case number 524 of 1967 of Survey Settlement Office was relating to the case of किसका कौन मोदी? रतन मोदी. Vatan Modi. BATA and Vatan Modi and others, and it had nothing to do with the plaintiffs of the case. The Learned Counsel submits that the entire case of the plaintiff was primarily based on the entry made in the Khatian by referring to case number 527-24 of 1967, and accordingly the such entry and accordingly if the order sheet in case number 524 of 1967 was not referring to, was not concerning the parties, then under such circumstances, the very basis of the claim of the plaintiff would not exist, and consequently the suit was fit to be dismissed. But this additional evidence having not been considered has caused prejudice to the appellant. Okay? During the course of arguments, the learned counsel for the appellant has placed the appellant in which miscellaneous case number 524 of 1967 CNT Act under section 87 under section 87 of the CNT Act has been mentioned. In the remarks column बोलेंगे इसको? In the remarks column,
No, what is there?
as by way of note, under the signature of Additional Settlement Officer Hazaribagh. During the course of argument, it transpired that the additional evidence which was sought to be adduced by the appellants was case number 524 of 1967, but was relating to case under section 90 of Chotanagpur Tenancy Act and was a proceeding of Survey Settlement Officer Hazaribagh. It is not in dispute that the proceeding under section 90 of CNT Act is appellate proceedings. After the order passed, नहीं appellate नहीं है, लाइए जरा CNT Act दीजिए.
It is a proceeding. First proceeding is 87, which can be filed within 3 months. But if one does not take recourse to that, then under section 90 after 5 years, it is the deputy commissioner who has the
It is not in dispute that under section 87, a petition for rectification of entry can be filed within a period of 3 months, and under section 90, the deputy commissioner has got or the revenue officer has the necessary jurisdiction, and the jurisdiction under section 87 is different from the jurisdiction of section 90. इसमें तो आपको legally तो कोई dispute नहीं हो सकता है ना?
करेक्शन दोनों में होता है.
हाँ, करेक्शन दोनों में होता है, लेकिन प्रोसीडिंग अलग अलग है, अथॉरिटी भी अलग अलग है.
अथॉरिटी तो सेम हो सकते हैं, क्योंकि रेवेन्यू ऑफिसर का डेफिनेशन दिया है.
However, during the course of argument, the case number 520, the order sheet, the certified copy of order sheet of case number 524 of 67 of Survey Settlement Office of Hazaribagh was admittedly mentioning section 90 of the CNT Act. And in that proceeding, upon the learned counsel for the appellant has also placed the plaint and written statement of respective parties and has submitted that it was the specific case of the defendant number 3 and 4 who had filed a written statement that the order in case number 524 of 1967 was fraudulently. That's all.
Judgment and
Huh. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2012 bracket close 8 SCC 148 para number 50 para number 36 to 52 to submit that as per order 41 rule 27 the document is through additional evidence is to be considered at the time of final hearing, and if the court finds it proper, if the court finds it difficult to pronounce the judgment, then such additional evidence can be looked into. He has submitted that had the appellate court looked into the aforesaid additional evidence, the decision would have been different, as the very basis of the claim of the plaintiff would have been demolished. Right? अब परसों वे कल तो नहीं हो पाएगा, परसों छुट्टी है for judgment on Thursday. आगे आप लोग का सब्सटेंशियल क्वेश्चन होगा, स्टेट कहाँ है आगे से? एक्सचेंज कर लिया?
नहीं नहीं अभी हम फाइनल किए हैं, ये हम साथ में दिखा देंगे।
हाँ
हमारे हिसाब से
Lordship, I have written whether the first appellate court has wrongly reversed the judgment and decree passed by the trial court by making out a third case. That 1, 2, 3, there are 3 places where it has made out a third case. The persons who had executed Arpanama only had fractional interest upon the suit property. Second was Shruti Kirti Devia had other heirs, and the original plaintiff was not the alone nominated survivor. This also no one had pleaded. Absolutely new. And second, third one is Arpanamas were not in terms of section 72 of CMPL. How surrender is done, all those have been discussed by him, whereas absolutely no one's case. Those Arpanamas were never in question. So this is one. Second one is whether the lower appellate court was right in holding that Exhibit 3 was the conclusive proof of possession as per section 84.3. Why this is important here? Section 84.3, it only says that a presumption would there would be a presumption of, but in 84.1 that has been taken by the appellate court. In 84.1 it says that once a publication is made, then it would be that would be conclusive proof of publication, only publication, not as regards the entry, the correctness of entry. It mixes the two and says that it is
whether the reversal of judgment and decree in this one, Exhibit 1B and 1C.
Yes,
you have
yes.
said that it is beyond the pleading.
Beyond pleading, the trial, appellate court said. And the fourth one is
without meeting the reasons.
yes, without meeting the reasonings of the
In a case where the reasons are not met, The second appellate court will decide it.
It can, but it has the power.
It has the power.
It has the power. It has the power because it is an appellate court. Even in under Order 41, Rule 33, even in second appeal, that power is there with the second appellate court.
इसको admit कर लें सारे questions. Essay number 219 of 2022. The learned counsel for the parties are present. Counsel for the appellant submits that the impugned judgment of the appellate court is a judgment of reversal, and has further submitted that the following substantial questions of law arise for consideration in the present case. He has placed the entire judgment before the scope of both the learned courts. Considering the aforesaid submission, let this second appeal be admitted for final hearing on following substantial questions of law. The respondents have already appeared.
They have always stated.
The respondent are the state authorities and are being represented by the learned counsel for the state, and accordingly no notice need be issued. Let the records be called for from the concerned court. अब कब करिएगा खाली इतना बताइए. ये है अलग से. CLT मत लिखिएगा, छोटा आपको टेंडेंसी एक्ट पूरा लिखिए, शॉर्ट फॉर्म में नहीं लिखिए कोई भी ऑर्डर. Close this case for final disposal on 27th March. आप तैयार हो जाइए, रिकॉर्ड कॉल पर करते हैं. Let the records be called committed to pass. और किसका है आपका पास ओवर है? और मिस्टर विशाल तिवारी कहाँ है? उनका नाम फ्लैश करिए. क्या आपके केस में?
I'm the defendant of the main title suit in lordship, and the order of the title suit has been affirmed by the entitled appeal also. So here the defendant has preferred this second. This matter relates to the declaration of title and possession over the land. It relates to two different khata. The first one is khata number 6 and the second one is khata number 996. I'll argue first on the limitation ground.
Limitation?
Yes, sir. The
It has
ground of
been-
limitation
it
has
has
not
been
been
dismissed.
considered. It is allowed by the in title suit.
It was barred by limitation.
Yes, sir. It is barred by
The
limitation.
declaration of title will become barred by limitation. Was
Yes,
there
sir,
any
Lord.
prayer for setting aside any sale deed?
Yes, sir. It is the setting aside of the sale deed.
Where is the relief? No. There is no relief to set aside the sale deed.
I'm not here praying for the setting aside of the sale deed, but the plaintiff they are considering the title of the property over a sale deed in lordship. So I'm not praying for cancellation of the sale deed, but as the sale deed is the main document for declaration of title, and the same sale deed is of the year 1979, and the suit is filed in the year 2001. So lordship, this is a law that the court must consider. Lordship will kindly see section 3(1) of the Limitation Act.
Who has been found in possession?
As per the appellant are in possession, and there is one.
No, not as per the appellant, as per the
There
findings.
is one report of the Anchal Adhikari of the year 2009 of the year 1991, in which in some part of the area the appellant are in possession.
We do not know. Where is the finding?
There is finding, Your Lordship. There is finding. But firstly, on the ground of limitation, Your Lordship.
Did you claim adverse possession?
Yes.
What is the finding on adverse
And
possession?
it is one of the issue in the.
What is the finding of adverse possession?
It is in favor of the plaintiff.
So your claim for adverse possession has been dismissed. They are not seeking declaration of any deed as time barred. How does the suit become time barred?
This is my first submission. There are a lot other submissions to Your Lordship regarding the report of the Anchal Adhikari, and there is one suit which is there is one.
पढ़िए रात भर पढ़िए कल आइए पढ़ के आइए ऐसे बिना पढ़े मत आइए ठीक है सेकंड अपील बहस करना इतना आसान नहीं होता Essay number 59 of 2022. The counsel for the appellant has commenced the hearing, but on account of paucity of time, the hearing could not be concluded. Close this case tomorrow. अच्छे से आराम से पढ़िए, ऐसे लिमिटेशन नहीं है। जो अभी पोजीशन में है उसका इस तरह से आपका एडवर्स पोजीशन का फाइंडिंग में अगर कुछ एरर है तो देखेंगे, अदरवाइज आप अपना टाइटल सिर्फ एडवर्स पोजीशन से क्लेम कर सकते हैं, बिकॉज दे आर क्लेमिंग दैट आर यू आल्सो क्लेमिंग थ्रू एनी टाइटल डीड?
Yes, Your Lordship. I inherited this property. This is
इनहेरिटेड दिस प्रॉपर्टी?
Yes, Your Lordship.
Next.
कहाँ गए मिस्टर विशाल?
Now place the
Hmm?
now place there.
जिसका जिसका पास ओवर था और भी पास ओवर थे मिस्टर रशीद थे,
Item
क्या
30.
हाँ क्या बस
एक्चुअली दो रीजन है, एक बाय मिस्टेक फाइल छूट गया है घर में, एक पहला, दूसरा ये कि सर्टिफाइड कॉपी के लिए एविडेंस और डॉक्यूमेंट्री एविडेंस का नहीं अप्लाई किए हुए, नेक्स्ट वीक में हो जाने से मेरे पास आ जाए, ये डिफिकल्टी है।
आप ऐसा कौन सा एविडेंस का आपको चाहिए? री एप्रिसिएशन ऑफ एविडेंस तो नहीं हो पाएगा, आपका का कोई ग्राउंड भी नहीं है कि कोई परवर्सिटी है, ऐसा तो कोई ग्राउंड आपने लिया ही नहीं है।
इसको नेक्स्ट वीक में सुन लिया जाए।
नेक्स्ट वीक में सर्टिफाइड कॉपी के लिए टाइम मत मांगिए।
ठीक है, नहीं मांगा।
ऐसे नंबर 25 और 2023। The learned counsel for the applicant seeks adjournment by submitting that by mistake he has not brought the file to the court. Close this case on next Monday. Here is Mr. Patti, are you looking for something? You have a case here? अच्छा ऑर्डर्स, देखिए ऑर्डर्स वाले जितने केसेस है ना, ये नॉन सीरियस लोगों के केसेस हैं, इसीलिए सब्स्टिट्यूशन है, ये है, कुछ टाइम से नहीं करते हैं, सब प्रोसीडिंग अवेट हो जाता है, इसीलिए 4 बजे का टाइम।
I am the coincidentally respondent, my lord. The appellant has not taken steps for substitution.
नॉट टेकन स्टेप्स, अवेट कर गया प्रोसीडिंग।
Your Lordship, in fact, I spoke with the clients. We have no information regarding the person who was substituted.
आपके पैर में क्या हो गया?
I fell down last time. Respondent number 1A who was substituted. The notice was served and it was returned as died. We contacted the clients. The clients said they have no information about it. And in the execution proceedings that is going on in the learned court below, there the substitution application that was filed, in that the person that the respondent has died, that is respondent number 1A, they have not even chosen to substitute that person. Only the remaining 3
क्योंकि
persons.
कोई भी ऑर्डर बिना पिटीशन के तो नहीं हो सकता, और अवेट तो कर ही गया, मरना मर गया, इसमें तो कोई डाउट नहीं है ना, तो फिर
Then I may be
you are the sole respondent.
the respondent 1 had died. There are 4 respondents in relation. 1 had died. That was substituted by further 4 persons. Out of them, 1A has died. So 1A, we have no information of the legal heirs. If they can provide us.
यही सब फेट है सेकेंड अपील्स का, इसीलिए जल्दी जल्दी जो भी मैटर हो कर लीजिए, वही ज़्यादा अच्छा है, जल्दी टाइम फिक्स कराइए और कर लीजिए, अदरवाइज देयर इज। हाँ क्या हुआ मिस्टर विशाल तिवारी को, क्या हो गया, कहाँ चले गए वो? तो 10,000 रुपीज़ का तो कॉस्ट तो हम ऑर्डर कर ही दिए थे।
नहीं, हम आइटम नंबर 4 से रिलेटेड, आई एम द रेस्पोंडेंट।
ऑर्डर्स,
यस,
ऑर्डर्स के लिए अगले साल, मतलब अगले साल नहीं, अगला वीक।
सम डेट में भी फिक्स्ड
डेट तो रहता ही है, लेकिन हम 4 बजे का टाइम रखते हैं, क्योंकि सुबह सुबह जो है ना 2 घंटा हम इस ऑर्डर्स में नहीं बर्बाद कर सकते, उससे अच्छा है कि कुछ ढंग का काम करें, नहीं तो पूरा दिन ऑर्डर्स में निकल जाएगा, सब्स्टिट्यूशन करते, रिस्टोर करते।
I am appearing on behalf of land user, and CCL is the acquired the land, but
since 1992
जो कोई बात
And
नहीं,
onwards.
अगला
till date. no
अगला
problem.
हफ्ता 4 बजे हम कोई मैटर नहीं रखेंगे, मंडे को एकदम पक्का, ठीक है?
Obliged.
आज मिस्टर विशाल तिवारी तो एब्सेंट हो गए, तो क्या सोचें 4:30 बजे कोर्ट खत्म। चलिए कल करें। नहीं, essay number 194 of 2023, the case was taken up and the learned counsel for the appellant had prayed for passing. However, neither the learned counsel is present in the court and the court time is also over. Therefore, this court is not inclined to pass any adverse order against the appellant. Post this case tomorrow. उनको खबर करके बोलिएगा फर्स्ट कॉल में कल नहीं आएंगे तो हम DFD कर देंगे। ठीक है, 4:30 बजे के बाद एडवर्स ऑर्डर नहीं करते हैं बाय एज अ मैटर ऑफ प्रिंसिपल।